Is it recording? Okay, good. I finally see you recording. Good morning, everybody. Thanks for your attending, and we're off, I think, for real on intellectual property today. We did a lot of getting acquainted last week, and we covered a few very basic principles, some of which I kind of want to go over here just by way of review. And then I want to get into some fun stuff about intellectual property and hopefully get to my story, which will make intellectual property not only resonate with all of you, but frighten you sufficiently to pay attention for the next 11 weeks. So with that, I wanted to start with a little bit of a review of what we talked about last week. Can anybody tell me what are the three forms of intellectual property? Come on, Sheng, I know you know.
I know there's a word and phrase, word copywriting.
Yep.
And
trademarks.
Excellent.
And patents.
Exactly, and I know you didn't look at the screen to get that answer either. Those are really important. Those are the three forms of intellectual property. Patents are anything that does something. Copyrights is anything that is recorded in a written or digital form. And of course, trademarks can be almost anything, but it's a design or a symbol or a slogan that represents a particular item for sale, a brand, a product. What can be patented? What do you have? What's the one thing you have to have in order to protect your intellectual property?
Documentation.
That's right. It has to be expressed in tangible form. That's the most important thing. Ideas are not protectable, but any form of expression is sufficient. So if you draw a picture of it, if you write it down on a piece of paper, if you store it on the hard drive of a computer, if you record it digitally, any form of expression at all is sufficient to qualify for protection. The only thing is that it's the idea, it's the expression that is protected, not the idea itself. And the difference between the two will become a little bit more evident as we move along. And what, the last thing I want to go over from last week, what is the one guiding principle of intellectual property that I want you to come away with? And it has to do with loopholes that we talked about last week. There's one place we always come back to when it comes to intellectual property. Whenever you have a dispute, whenever you have a question about who owns what with intellectual property, the guiding principle of intellectual property is that the invention belongs to the inventor. And you need to remember that when the time comes that someone tries to take your intellectual property away from you. The guiding principle since 1790, since the first Congress that wrote the laws on intellectual property convened, has been that the intellectual property belongs to the inventor. And that was recently re-articulated by our very conservative Supreme Court in a case called Board of Trustees of Leyland Stanford Junior University. And you don't have to remember any law or any Supreme Court cases for this course, but that case, that one particular case applies to everybody that's listening out there today, especially if you're a student at MIT. And that's a case that really sets forth a lot of the things that are going to concern you as students and as entrepreneurs as you go out into the real world. And remember, it was that case that held that intellectual property rights belong to the inventor. except under very extraordinary circumstances where Congress has stepped in or where the parties agree to give up those rights. And that's something that is really, I think, terribly important for everyone to remember. All right, so a couple of things before I tell my story I wanted to go over that I didn't quite cover last week. And this is sort of like a fourth form of intellectual property, which doesn't really have a protection in the form of federal statutes, but is nevertheless a form of intellectual property that by common law and by the practices of the parties also qualifies for protection, and that's confidential information and trade secrets. And what do I mean by confidential information and trade secrets? Well, we talked last week about Coca-Cola and its formula. One of the reasons why Coca-Cola chooses to keep its formula a trade secret is that if they were to patent it, first of all, they'd have to disclose it to everybody. And then after 21 years, the patent would expire and everybody would be able to bottle their own Coca-Cola. So there's a really good reason not to use formal intellectual property protection for something like the formula for Coca-Cola. And so what do? They write it down on a piece of paper and they literally put it in a secure safe down in Atlanta, Georgia. That's an example of a trade secret that which is a different form of intellectual property and a reason why formal intellectual property protection does not actually do or accomplish the purpose of the business. Because once you protect a piece of intellectual property, either by copyright, trademark, or patent, you have to disclose it. You have to publicize it. You have to file it with the United States Patent and Trademark Office. And everybody gets to know what it is. And as I said, at the end of 21 years, Coca-Cola would be out of the Coca-Cola business. And the same goes for confidential business practices and methods. Confidential information or trade secrets is a form of intellectual property that has commercial value and is not in the public domain, but is important to the business. And so, in order for it to qualify as confidential information or trade secrets, you have to treat it confidentially and you have to treat it like a trade secret. If Coca-Cola were to be careless with their formula, and then you and I, for instance, maybe the class opens up its own bottling company using the Coca-Cola formula, and they sued us, we would probably win that case if Coca-Cola happened to be careless with their formula. So if you let it slip out, if you mention it to your friends, if you disclose it when you're sitting having dinner, or if you go to a trade fair or something and talk about your confidential idea, it's out there. It's now considered in the public domain, and it's no longer a trade secret. So it literally has to be, on a piece of paper, in a safe, at corporate headquarters in Atlanta, or something similar to that, to qualify for as confidential information or trade secret. If you don't treat it as confidential information, it won't be protected. That's why when you go to work for the Coca-Cola company, or when you go to work for Google, or when you go to work for any of the companies that most of you will be recruited by, you sign documents that require you to keep confidential the trade secrets and secret information which is disclosed to you in the course of your employment. If the companies didn't do that, then you would be free to use that information. You'd be free to sell it. You'd be free to make use of it in your own business. And there's nothing the company could do about it. That's why you're required to sign non-disclosure agreements and confidentiality agreements. It's to protect that information which the company deems to be essential to their business. All right, some examples of confidential information or trade secrets. We already talked about the Coca-Cola recipe, but data compilations. Can anybody think of a a data compilation that might be an example of a data compilation. I'm going to date myself, but probably only one other person will know what this is, and that's Professor Eager. But the Yellow Pages, and has anybody ever heard of the Yellow Pages? I forget sometimes how young everybody is, but there used to be a thing called the Yellow Pages, which was a big yellow book published by the phone company where businesses would advertise. It was kind of like a hard copy of the internet, to tell you the truth. But that's an example of a data compilation. Customer lists and customer and supplier lists. Of course, companies often want to keep these things confidential because of the pricing. So if you're a company that produces titanium goods, and you have a great source of titanium in Russia that gives you titanium for a good price, you want to keep that source confidential because the other titanium manufacturing customers or companies that are your competition would use that information to your disadvantage if it became generally known. Other examples, business operation manuals, recipes we already went over, blueprints and designs, internal business processes and methods. You know how Twinkies are manufactured? You know how the cream filling gets in a Twinkie? That is the machines are patented, and the process for producing the filling and injecting it into the Twinkie are very closely guarded trade secrets of whatever the name of the company is that owns Hostess, and produces Twinkies. Financial information. Businesses have audits that they use with banks to secure financing. That's the kind of information you don't want your competitors to have. You don't want your employees to disseminate. So that's an example of confidential information or trade secret. And of course, business plans. If we put together a business plan for microchips using electronic polymers, we're going to want to keep that information confidential because it could be a competitive disadvantage to us to release it. All right, those are some examples of confidential information and trade secrets. Now, how about business ideas? Are business ideas something that you can protect? The answer to that question lies in the question itself.
I would say they should be guarded, but they're not necessarily protectable by patent because it's not tangible yet.
Exactly right. Exactly right. An idea is something that needs to be closely guarded because it cannot be protected unless expressed in tangible form. So it's the expression of the idea that's important. Now, can you think of an example? Anyone think of an example of a famous business idea which was not expressed in tangible form and therefore not protected? And I'll give you a hint. It's a business idea that's worth about $265 billion today.
Facebook?
Yeah, exactly. Ask Cameron and Tyler Winklevoss. Exactly, exactly. If they had taken this course when they were at Harvard, I'm sure they would have been smart enough to write the idea down before they went and talked to Mark Zuckerberg about it. As it was, the litigation probably set them up pretty good. Oftentimes, cases are settled not because of the merits of the case necessarily, but sometimes they're settled because of the odious nature or the relative odious nature of the litigants. In other words, you have to predict whether a jury is going to believe anything your client has to say. And even if you don't have any evidence, if the jury is more likely to believe your client than the other, sometimes those cases get settled. But that's a perfect example of an idea worth $265 billion today with, what is it, 2.8 billion followers that wasn't protected. All right. So the originators of an idea often feel cheated when their idea is commercialized by others. But it's important to appreciate that more goes into a successful company or a product than just an idea. And that's the reason why it's not protected. You know, it's great to, you know, sit in a living room, in your comfortable living room chair and come up with lots of ideas. But as Professor Eager has, you know, really, I think, emphasized again and again, there's a difference between, you know, the theoretical and the practical. Bringing these sorts of things to life requires a great deal of effort, thought, and investment. And that's why we don't protect ideas, because anybody can have one of those. It's the industry and the investment associated with the fixed expression of these ideas, the practical application of the ideas that we have decided is worth protecting. I had some examples of that, of famous business ideas. They don't always pan out. Can anybody think of an example in the social media era that or realm that didn't pan out? Remember before there was Facebook? Is anybody old enough to remember what there was before there was Facebook?
MySpace.
Great example.
MySpace.
Excellent example, MySpace. How many MySpace users are there today compared to Facebook? Well, I know MySpace doesn't have 2.8 billion, that's for sure. What was the other one called? Was it FaceTime? I can't remember what it was. Anyhow, it'll come to me. But oftentimes, you know, people that had an idea or even those who have expressed it in a tangible form in some way feel cheated. I wanted to run through a few famous ideas or a few famous intellectual property disputes for you that kind of illustrate the difference between ideas and the expression of ideas in a tangible form. Anybody see the movie, what is it, Hangover 2? Where one of the characters wakes up in the morning, he's in Thailand, and when he wakes up, I think in the first movie, the character had lost a tooth. In the second movie, he had a Mike Tyson-like tattoo on his face. Does everybody know what I'm talking about? Has anybody seen this movie? Or am I, okay, good. I'm glad I'm not just rambling on like a crazy person. All right, so the movie has the character with this tattoo on his face, and the fact is that Mike Tyson's tattoo artist, Victor Whitmill, sued Warner Brothers, claiming that his use of the use of that design in the movie was an example of patent infringement, or excuse me, copyright infringement. Has anybody heard of that lawsuit? Does anybody know how that turned out? He lost. And the reason is he didn't formally get protection, and it was deemed to be essentially in the public domain. It doesn't mean he couldn't have protected it, but in that case, it was decided that he didn't protect it adequately. One dispute that goes back a little ways, but is illustrative, is the fight between Isaac Newton and Gottfried Wilhelm on who invented calculus. The German mathematician claimed that he had invented calculus, but when Isaac Newton published his book Optics in 1704, he claimed to be the father of calculus, although he didn't call it calculus, but he claimed the idea was his and that he owned the rights to it. And of course, this involved international politics. Germany wanted its citizen, Germany wanted the bragging rights for having invented calculus. And of course, England wanted to have the bragging rights for having invented calculus. And there was a lawsuit about it. Newton claimed to invented calculus when he invented what he called the science of fluxions. And he said he wrote about this in 1665 and in 1666, and he said, there's the idea, fixed intangible form, I win. Leibowitz, however, took the easy way out. He passed away before their lawsuit could be resolved. So nowadays, historians generally credit Newton and Leibowitz for being the co-creators of calculus. But again, it was Isaac Newton pointing to his description of the math of calculus in 1665, where he said, there's the expression in tangible form that proves I'm the owner of this intellectual property. Just an example of how an idea has to be expressed in tangible form. There are so many examples of this in history, and so many famous intellectual property disputes that illustrate these things. Anybody hear of Napster? I know that some of this is history, but I think you're old enough all to know about Napster. A student over at Northeastern University created Napster. And it was a way of basically sharing music. Does anybody know what happened to Sean Fanning and his Napster company? Has anybody been on the Napster site recently and downloaded any music? Because you can't. Napster no longer exists. Napster was sued by, well, they were sued by everybody, but at least A&M Records, I think that's only because A is the first letter in the alphabet. The number of companies that sued Napster number as many, I think, as there are letters in the alphabet. But this lawsuit that was litigated out in the Northern District of California and eventually went to the Ninth Circuit Court of Appeals out there, decided that Napster was infringing on the copyrights of the artists or the companies that own the rights to the music, and Napster went out of business. Grokster is another example of a MP3 music share system that again went by the boards in a few years later in 2005. But they're examples of copyright infringers, and these cases really represented sort of the leading edge of intellectual property law and its development. You know, when Congress wrote the first laws involving copyright and trademark and patents, nobody had imagined MP3 players or social media. So the law has been evolving. And the cool thing about intellectual property law, it's very elastic and it adapts to whatever the new technology is. But the principles that it must be expressed in a tangible form, that the inventor owns the invention, generally speaking, unless they have their rights taken away by Congress or voluntarily give them up. Those basic principles all apply uniformly, no matter what the technological expression of the invention happens to be. So even though nobody thought of social media back in 1790, the principles that were laid down back then and which we follow today are elastic enough to apply to any new technology, including social media. Another fun sort of intellectual property dispute, but illustrative of one of the things that we're going to talk about in this term, again, have you heard of it? Weird Al Yankovic? Okay, at least I have. And, he used to do a lot of parodies of songs. And what he used to do is he'd contact the owner of the song, usually the songwriter, and say he wanted to do one of his goofy parodies. And he'd always seek their permission. And most of the times he'd get his permission. But every song that Weird Al Yankovic did, he had the permission of the owner of the work. But then along came Two Live Crew, and they wanted to do a takeoff on Pretty Woman, Roy Orbison's song. And since Weird Al Yankovic had sort of established the protocol for this, they went to Acuff Rose Music, who owned Roy Orbison's works, and said, hey, we'd like to do a takeoff on Pretty Woman. Could we have your permission? And we'll pay you a licensing fee and we'll give you credit. Unlike the artists that were dealing with Weird Al Yankovic, Acuff Rose said no. They said, you can't use our song. You can't use Roy Orbison's music to do a takeoff. They changed Pretty Woman to Big Hairy Woman, Bald-Headed Woman, and Two-Timing Woman. So maybe Acuff Rose kind of objected to what they were doing with Roy Orbison's music, not how they were doing it. But in any case, they said no. Anyone have any idea about what should have happened in this case, or what did happen? For instance, can you go out and buy Two Live Crew's recording of As Clean as They Want to Be? The answer is yeah, you can. And that's because a parody is does not constitute an infringement of intellectual property rights. Parodies fall into the category of commentary and commentary or discussion or education are exceptions to the rules of intellectual property infringement. Basically, when Acu Rose Music sued, they took the case all the way to the Supreme Court, and the Supreme Court said, lighten up. You can, Two Live Crew can do what they did in this case because it's a parody. And does anybody remember Justice Souter, David Souter? He was from Maine, real conservative kind of guy. I always find it interesting to imagine, a conservative jurist like David Souter sitting down and writing the majority decision about music produced by a rap group. But anyhow, David Souter said, reiterated the principle that parody or any form of its comment necessarily springs from recognizable allusion to its object through distorted imitation. Its art lies in the tension between a known original and its parodic twin. Spoken like a true conservative jurist. What he's basically saying is artists should be free to create, and there's a big difference between Pretty Woman and what Two Live Crew produced. And it's that difference that makes the distinction and makes it separate. And in fact, it is itself copyrightable, protectable as a copyright. And so it's important to understand that, especially when it comes to copyright, the solution to whether or not it's protected or not usually lies in the name of copyright. If you copy it, you're probably infringing. But if you are not copying it, if you're changing it in a small way, and that can be a data compilation like the phone book where you rearrange the data alphabetically or numerically, or it can be a song parody where you change the words or the melody sufficiently to create a work that's distinguishable from the original. So long as you don't copy it, and so long as you change it in some way, you're probably creating enough distance between your work and the protected work so as to not be in danger of infringement. There are lots of examples of famous sort of intellectual property disputes that kind of make, I think, the subject, kind of fun to talk about and analyze. And as time goes by through the term, I'll revisit some of them, because there are products that you come in contact with every day that maybe you don't realize it, that have been the subject of intellectual property disputes. In fact, does anybody recognize this thing? I'm sure every one of you have held one of these in your hand at one time or the other.
Bag.
It's a bag by a particular company, by Apple. And we'll maybe talk about it next time, but you'll be amazed at how many examples of intellectual property are contained in this one little bag, and how much litigation has gone on when it comes to this little bag. But there are dozens of examples of intellectual property, from the design of the logo on the bag to the way the design itself is made, to the way the bag is manufactured, to what it's made of. Dozens and dozens of examples of intellectual property just in this one little bag. You can write an entire doctoral dissertation on intellectual property, examples of intellectual property, just using the Apple bag as an example. Anyhow, here's the Fizzle I was talking about earlier. Friendster, that's the name of the company I was trying to think of. Friendster predates, I'm talking about here famous successes and fizzles when it comes to intellectual property. I'm sure you've all heard of Google. Well, they acquired YouTube for 1.65 billion. Today, YouTube, and I had to update this this morning, today YouTube is worth about 160 billion, while Google is worth about 525 billion. That's a pretty good return on a $1.65 billion investment. The other example I was trying to think of earlier was Friendster. Facebook has 2.8 billion users and is worth about 265 billion. And Friendster, which is basically the same idea that came along 2 years earlier, has today 8.2 million users and is worth about 26 million. Yet it's basically the same thing. Everybody who's a member of Friendster, has an account on Friendster, raise your hand. I thought so. Everybody who has a Facebook account or has had a Facebook account, raise your hand. Exactly. Famous successes and fizzles. All right, so that brings me to my my cautionary tale, as I mentioned last week. In order to make this course resonate for you, and in order to sort of demonstrate the principles of intellectual property that I think that you need to take with you, especially as structural materials students and engineers in the future, I have a story. And it basically involves a famous technical university whose name will go unmentioned. But let's just say it's a famous technical university in the city of Cambridge, located somewhere on Massachusetts Avenue. And it involves a student who eventually got her doctoral degree from this famous university, but attended as graduated as an undergraduate as well. And this is a picture of what the big fight was all about. And the fight involved this famous technical university and one of its students. And the story goes like this. Once upon a time, a student in course 2.014 was involved in a class project involving aluminum fuel. And they were trying to develop a way that aluminum fuel could be used as a fuel for a reactor. In this particular case, a reactor that was going to propel an underwater, autonomous underwater device. And the class, of course, that it was involved in this project was using all various ways of, or experimenting with various ways of producing this aluminum fuel. And one after another had problems. It would freeze the pipes and some would freeze the pipes in the reactor, and others had other types of flow problems or wouldn't produce enough fuel. Aluminum, as everyone I'm sure in this class knows, is very reactive. And so its potential as a source, a power source, has been the subject of a lot of investigation and research, most of it massively unsuccessful. But anyhow, this class was involved in trying to come up with this aluminum fuel, and one experiment after the other didn't work. And this student, who had actually been working in one of the labs at MIT on this aluminum fuel project, one of the iterations that didn't work happened to grow up on a farm and was taught never to throw anything away. So they took the aluminum fuel that was discarded and was going to be turned, just basically thrown out as contaminated waste. But because they were taught never to throw anything away, kind of cleaned up the aluminum spheres. They were in the form of spheres, put them in a piece of plastic Tupperware and threw them in a desk, thinking maybe, why waste this aluminum? They went back to the class, and they went back to developing a method for producing this aluminum fuel. The class eventually went in a particular direction where they were able to come up with a way of producing this fuel, and the student forgot all about it. A few weeks later, went back, was cleaning out the desk, and found the Tupperware containing the aluminum spheres, and saw that they'd all turned black. And they couldn't understand why they'd turned black, and there must be some sort of chemical reaction here that she didn't understand. And so she took the spheres and began studying them on her own time and after class, and eventually determined that because of the highly reactive character of aluminum, that when stored for a period of time, they produced an oxidizer, obviously oxygen. And so in order to find out how much oxygen they were producing, she designed the experiment that I showed you, and found that this aluminum was producing a great deal of oxygen and hydrogen. And she had the idea that this would make a really good machine for producing hydrogen. And so she told her instructor about it, said, I was supposed to throw these away. I didn't. I've studied them. And what do you think? I want to file a provisional patent on this process because I think it could lead to the invention of a machine that produces hydrogen at an affordable price. The instructor said that that was a great idea. Go ahead. Even helped with the patent application, and they filed it, and it was approved by the United States Patent and Trademark Office. And on her own time, she began to develop this machine even more and was able to prove the concept. And I don't know if you know what it costs to produce hydrogen, but hydrogen is an expensive item to produce. And anybody that can come up with a machine that produces it inexpensively can make a lot of money. In fact, the design had so much promise that as part of her doctoral thesis, she got the approval of the famous technical university to develop this machine. And I don't know if any of you have gone through this process before, but if you're going to do something like that at MIT or at this famous university that I'm talking about that will go unnamed, what the university will often do is they will help prosecute the patent for you and in fact try to find ways of practicing it and commercializing it. And in return, they split the profits with the student. So they convinced the student to turn over the rights to this machine to the university in return for a promise to share the profits if it ever became commercially viable. The student went off and finished their doctoral thesis, developed this machine, and decided that they wanted to commercialize it. The famous university went about the business of attempting to find commercial markets for the machine and could find none. And so they decided that they didn't want the patent anymore. No money could be made out of it. And so they offered to sell the rights to the machine, which they shared with the student, back to the student. And the student, because the student felt that she had more foresight than the famous technical university, went out and borrowed the money from her parents to buy the rights back. And by that I mean she had to pay the costs that the university had incurred in bringing the patent to maturity. And it was a considerable amount of money. It was $46,000 in this particular case. In any case, she borrowed the money from her parents, wrote a check to the university for $46,000. The university then assigned the rights exclusively to the student, and everybody shook hands and waved goodbye, and they went on their merry way. Well, the student had some ideas for the development and the commercial exploitation of this patent that the university did not occur to the university, and began to market the hydrogen generating machine commercially. And suddenly it became very valuable. And in fact, it came to the attention of a famous laboratory named after a president, which is affiliated with this technical institution. But I won't tell you what the actual name was. But it's the name of a president of the United States, not Washington. And it's a laboratory famous for its research in conjunction with a famous technical university in Cambridge. Anyhow, this invention came to the attention of this research laboratory because they were working on a government contract to make fuel for systems of use to the Navy and the Air Force. And so they wanted to get their hands on this patent because they couldn't very well practice the patent and couldn't pursue the valuable research grants from the government which is the lifeblood of this place, unless they owned the rights to the patent. But the university had given away its rights to the patent, not given it away, but they'd sold the rights. And so they were exclusively owned by the student inventor. So the university decided that they were going to go back on their agreement with the student. And they cited a obscure statute called the Bayh-Dole Act, which is basically a law that Congress passed that said that if you work on an invention that is substantially funded by the United States government, then the United States government owns the rights to the machine, to the invention. And the university called the student up and said, we want our invention back that was now worth tens of millions of dollars potentially, even though we sold it to you, because we just discovered that the class that you were involved in was partially funded by a secret fund named after a famous aquatic animal, which we didn't tell you about, which we didn't tell the instructor about, and nobody knew about. But now we think since some money might have gone into that class, we own the patent. And whereupon my law firm got engaged. The long story made short, since it's 9:51, is that that principle that I talked about at the beginning of the class, where since 1790, the Supreme Court has favored the principle that inventions are owned by the inventor, won out. Even in light of the Bayh-Dole Act, which Congress passed, and which it said you could take the rights of inventors away if government funding was involved. But whereas this particular invention was developed by the student on their own time, using minimal facilities, basically a sink and a flask and a few tubes that anybody could acquire, the inventor in this particular case won out over the university, and now is actually working with the university and its famous research laboratory, and has granted them a fee-free license to do research. But they're well on their way now to being a multimillionaire because of this invention, but which they had to wrestle away from the university. The moral of the story is, and the reason why this course exists, is because when it comes to the very valuable intellectual property that some of you are likely to invent in your times as students and as entrepreneurs, and when you go out into the workforce, when it comes to that stuff, companies and even institutions whose primary object is education will stop at nothing to wrestle that intellectual property away from you, even if it means inventing an entirely false scenario about phantom government funding. It's very hard when you're all by yourself, when you get a letter from a multi-billion-dollar corporation, which includes research laboratories and institutions of higher learning. It's very hard not to be intimidated by a letter like that. And oftentimes, intimidation is all these companies need in order to wrestle this property away from someone. But my advice to you is to remember that overarching principle of intellectual property law, that the Generally speaking, the invention belongs to the inventor. And don't let anyone intimidate or talk you out of that, because they could be talking you out of a very comfortable life as a multimillionaire. I know you have places to go. Any questions before we finish up?
I have a question. Did the Institute change its policies, procedures after that incident to, I guess, maybe not have it happen again?
Great question. Great question, because that case that I cited to you, Leyland College case, which is the sort of the guiding principle, which basically, have you ever heard of the Broward Institute and CRISPR? Okay, that's an example, another example of hotly disputed intellectual property rights, and we'll be talking about that case. When that Leyland case came down in 2011, every university from the Atlantic to the Pacific panicked, because they had been operating entirely on the assumption that whatever happened at a university belonged to them. And when the Supreme Court put their foot down and said, no, we're going to respect the rights of the inventor unless there is a compelling reason to take that right away, every university from Atlantic to the Pacific changed their operating principles, and they started sticking papers underneath the noses of students that would deal with this gap that they had not been aware of before the Supreme Court's decision. So in Boston, you have very, very, very good law firms full of people in little gray suits with sharp pencils, writing agreements, kind of like the ones that you, when you hit I agree, when you download music, writing agreements to stick under the noses of people like you to take away those rights. You might call them God-given rights, at least from the standpoint of an intellectual property lawyer. They are God-given rights. They are given to you by the United States Constitution and the Supreme Court of the United States. So a lot of universities are creating very intricate documents for students like you to sign in order to deal with that problem for them, because it's a problem for their endowments. They have always counted on this revenue, which they thought or they presumed was theirs, but which our Supreme Court has said, no, belongs to you. And so you got to watch out for that kind of stuff. And one of the reasons that we're doing this course is to show you how to watch out for that stuff. But yes, universities have, rather than think of ways of promoting education and the dissemination of information and knowledge, rather than support students, rather than to help students become millionaires, they think of ways to make themselves richer before they make the students richer. That's just the way of the world. I'm sorry that it took so long for this lesson to become clear to you, but let me tell you, it is the reason why I represent people like you rather than the engulfs and devours of this world, because I think that somebody should be out there protecting the rights of the students, of the inventors, and someone should stand for the dissemination of knowledge, not for making very rich institutions richer than they already are.
And if you go to the technology office of this famous university, you will find that they will not explain the details to you. They will give you their take on the story. And not only did they ask students to sign a different agreement, they put a new agreement under the noses of all the faculty, 1,000 faculty, and said, oh, we have to have you sign a new agreement. And I know of one professor who refused to do that.
I do too. I do too. But
And he was asked finally if he wouldn't just sign it out of respect for the university. Why wouldn't he sign away all of his rights to the university? Just out of respect for the university. And when he didn't do that, they had his department head come and ask him. And when his department head asked him, he explained to his department head about Leland Stanford University. And it was the inventor who won in front of the Supreme Court, not Stanford University. It was the inventor who won. And he had explained to his department head that he really didn't think he should be a shill passing lies on from the administration of the university, and it would be best just to let the matter drop. That all occurred 11 months ago. So have they changed anything? I don't think so. But when threatened with the facts, they would capitulate.
The reason I went to law school is because I wanted to be a social architect. And actually it shows that teaching this course, not only do I have an impact on the lives of students, but I've had an impact on the lives of people a lot smarter than me who are on the faculty of this school and others. And so that's what makes not only doing what I do for a living, but teaching you what I know worthwhile. And I hopefully from this point on, you're a little smarter than you were when you came in. We'll be able to protect yourselves.
Okay,
Any other
one
questions?
lesson is don't sign things if you don't understand them.
That's right. Call your lawyer. Call me.
Okay.
All right, guys. See you next Wednesday.
Thanks.
No other questions. And next Wednesday, we're going to be talking about paper bags. Your assignment, this is like guessing the number of beans in a jar. Guess how many patents or examples of intellectual property are represented by this humble empty bag. Okay?